Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I wanted to pick up on a case that I read about in some legal news today, relating to something that I do see from time to time cropping up around perhaps what's been offered at interview and in initial offer letters versus perhaps contractual documentation later on. So what had happened in this particular situation, somebody had gone through a recruitment process and had met with a particular law firm, and discussions had obviously taken place around things like salary and when he might start, including that he would work in this particular office, that he would have car parking, be paid a particular salary, etc. So the individual accepts that offer, is obviously very pleased to get the job, and some time goes by and then the firm sends out the contract of employment. Nowadays, of course, you have to give people their contracts of employment on day one of employment, or at the latest on day one, rather than the month period that we used to have until a few years ago. So the individual receives his contract of employment and realises that the place of work clause in that contract specified not only that he would work in the office that he thought he'd agreed to go and work in, but potentially that he could be asked to work from a sister site. So another location that was a lot further away from him, and in particular in his case further away from his children's nursery or childcare facilities. So he flags up, hang on a minute guys, this isn't what I'd agreed to. I'm not able to work from that other office location, at which point the firm has obviously said, well, you know, standard term in our contract, that's what people who work here agree to. Perhaps not unsurprisingly, the employee just handed back everything that he'd been given from the firm and said, well, I can't comply with that. And it ended up in the employment tribunal. Now, in order for there to become a contract of employment, certain ingredients are needed. So offer and acceptance, and something that's called consideration. Quite often that will be something like the employee changing their position in connection with that offer. So something like handing in their notice at a previous employer would count. So the contract has actually come into place before the written contract. Normally, if I draft an offer letter, I will actually say in it that it is also subject to the detailed wording of the full contract that's maybe following a little later. The judge in the particular case agreed that the action in issuing the contract with a secondary place of work in it was moving the goalposts, in effect a fundamental breach of contract. Now, obviously, the person hasn't got 2 years service at this point, so they can't claim constructive dismissal in connection with that breach in the same way as somebody with longer service might, but potentially it justifies their walking away and then claiming any losses flowing from that breach of contract. So that's going to be their notice period. So for somebody professional like a solicitor, that's going to be a longer period of time than just a week, which would be the statutory position. In this particular case, it was agreed at 1 month. Obviously, if there was a term in the offer letter that somebody would have 3 months notice, then it would be their salary and benefits for that 3 month period. So the particular firm in this case have had to pay out just over £1,500 in connection with that. But obviously there might be circumstances where there's a bigger issue, where it goes to some kind of discrimination law as well. So if it had been a female employee where there was a requirement to work from 2 locations and she had childcare duties, I suspect a court would still accept that more women take on the childcare duties rather than men, and that there's a form of indirect discrimination then when there is that provision, criteria or practice requiring the working from a particular location. Same with a disability, perhaps if the employee had a disability that was going to be the barrier to them perhaps travelling and working from a particular location. So you need to be very careful about what you put in your offer letters and make sure it reflects all the terms of the things you're going to want to have in there. Otherwise, you could find yourself in this kind of pickle like the law firm did in this case. If you've got any questions, please do not hesitate to ask. It's adenton@refreshinglawltd.co.uk.